thing that we're sort of pushing on the drumbeat, which is the FBI planted and created child porn evidence. That's everyone should be concerned about that. But what are maybe like the top 3 or top 5 other things that people should be aware of that were problematic in this case?
So in terms of the actual case and all the transcripts, I've really been very narrowly focused on the tampering issue, because I don't know much about, Nexium as a group. Everybody that I've met has been very nice, but I'm very narrowly focused on the tampering issue. And you're right, it is very, very concerning. It boils down to the FBI manufactured child porn and planted it on Mr. Raniere. And that is something that everybody should be concerned about. And there's not only the initial crime of creating the child porn and planting it, but then there's, the cover up often can be worse than the crime. So, the perjury at trial, lying in order to cover up their tracks and what they did. I mean, we have very specific instances of at least one FBI agent, saying things about technical details of the case that simply aren't true, that he, should have known better. And so, there's the initial crime, and then there's the cover up as well. And we have evidence of all of that.
And that evidence is all going to be, if you get it's a motion for an evidentiary hearing. Is that right? That's where you're
correct
at right now.
Yes.
And what's the state of that?
So there's an appeal that was filed before I came into the case. So think about it. There's a trial court down here, and then after a trial, there's an appeal. So that's at a higher level. And there was an appeal that was filed in this case before I came in, although I did file a supplement to it. So that would be at the appellate court level. A motion for a new trial based on the tampering has to be filed with the trial court. So the same judge who heard the actual trial, or at that level, that's the district court level versus the appellate court level. So right now, because the appellate court is deciding on the appeal, the motion that I filed for a new trial is sort of frozen in the district court right now.
So it's sort of complicating. Are those two things complicating each other? Or they're? I'll just put it frankly, because I think that the hour is getting late, and we should all talk truthfully. Obviously, the judge doesn't want to hear that there was some problem with some decision he'd made, and you're going to bring a bunch of attention to it. So you file a motion for an motion for retrial. He and his buddies hate that story.
Correct.
So then there's the appeals court, which is hypothetically a different entity. It's not, but it should be hypothetically a different set of people.
It is. It's 3 judges that are different than the trial judge in a different courthouse. So
there's an appeal that's gone on. Is that a different set of attorneys, or are you also working that appeal now?
No, I argued the appeal,
okay.
And we're waiting to hear back from the appellate court at this time.
And so to make sure I've got this correct, and I don't want to misrepresent it, in the appeal court, in the appeal situation, there's a presumption of guilt at that point. You have a much higher barrier to try and affect any change in an appeals court, because he's already convicted. We don't have to even give him the presumption of innocence. Is that just for the appeal?
Sure. Yeah. I mean, the presumption of innocence happens at a trial. And, if you were to look statistically at appeals, very few appeals get granted. And if you were to look at case law that's developed from, we get case law from appellate courts, right? So when something happens in trial, an attorney will bring it to an appellate court saying, hey, this judge did something that wasn't right. This judge let in all this evidence that was prejudicial, that had nothing to do with the case. And then the appellate court reviews what the trial court did. And I mean, it's just overwhelming odds that the appellate court is going to approve what the trial court did, especially if it leads to a conviction. Basically, appellate courts are in the business of preserving convictions, right, wrong, whatever. That's what, if you were, if appellate court decisions were, if you could bet on them, you would just make all the money in the world by betting against somebody accused of a crime or somebody convicted. So they basically, for the last 40 years, they have a track record of eviscerating our Constitution and our constitutional rights.
And okay, so that's the appeal. That's the state of the appeals court. And I'm going to want to come back to that because I want to hear what the arguments were there. But I do want to come back down to this lower court where you've done a motion for a new trial. And what is the status of the motion for the new trial?
It's on ice because of the appeal. So we have the appeal in the appellate court, and I filed the motion for a new trial, and the trial court said we're not going to touch this until the appellate court is done.
They're passing the buck off.
They froze it on ice, yes.
So, and the appeal process could take years, or it could take decades, presumably.
Nah, not decades, but yeah, it could take a long time.
Do you have any recourse before we get back to the appeal? Then, do you have any recourse in terms of them claiming this conflict or passing it off? Meaning, they're passing the buck. The lower court's passing the buck to the higher court, which there's obviously an argument for that, right? We don't want to deal with it because there's a higher court that's already taking it, and the higher court has stronger, more power than the lower court.
But they are two separate issues. So the tampering motion was in the trial court, but other motions like this and this and this happened in the trial. That's in the appeal. So the appellate court does not have any of the tampering issues right now.
And can you enter new evidence such as that into your appeal? It would be highly unlikely, or unusual, I would think, because typically we're relitigating the lower court's decision in an appeal, right?
Correct. Yes. Yeah. So we're looking at what the trial judge did and what the government did in an appeal. And the tampering is based on new evidence. And so the appellate court is basically looking at the record, right? They're reading the transcripts and that kind of thing. Yep. It's based on the four corners of the document. Whereas what we need is a motion that allows a judge to look at new evidence, and that can only be done at the district court level. But I can tell you, I'm not going to stop. These issues need to be brought to light. A lot of our tampering issues we can prove to a scientific certainty, and this is by using top digital forensic experts who all agree with each other. We didn't just go get and we didn't get one or two. There's many different experts. I cited 3 of them in my filings, and they all concur with each other that the tampering happened. And again, some of them are proven to a scientific certainty.